Good morning, everyone, and thank you for attending Thompson Coburn's webinar, Navigating HR Issues During the COVID-19 Emergency. First and foremost, we hope you and your loved ones are safe in this highly unusual moment, and we appreciate your time this morning. So again, thank you for joining us. My name is Nelson Williams. For those of you with whom I have not yet had the pleasure of working, I'm a partner in our St. Louis office where I primarily practice single plaintiff and class action litigation. Before we begin, we have a few housekeeping items. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We will try to answer those questions during the webcast. However, if a fuller answer is needed or we run out of time, we will subsequently answer the question via email. A copy of today's slide deck is available in the resource widget. We encourage you to download any resources or links that you may find useful. Finally, you can find additional answers to some common technical issues located in the Help widget at the bottom of your screen. This webinar is CLE accredited in Missouri, Illinois, and California. CLE approval is still pending for Texas. HRCI and SHRM approval are also pending. We award CLE based on attendance for the entire 120 minutes. From time to time, you will be required to click a pop-up screen to reflect your continued engagement. Simply click the icon to acknowledge you are still actively engaged. We value your opinions and appreciate your participation in today's webinar. So let's begin. To start things off, my colleague, Colin Pajda, will provide you with an overview of federal COVID-19 leave law. Colin practices in our St. Louis office and has spent considerable time parsing through the newly enacted laws. Colin?
Thanks, Nelson, and good morning. We know that you have been hearing about the Families First Act a lot over the past month, and we also know that there's been a lot of confusion about what the Act requires. What I would like to do this morning is to give you a brief, practical overview of the basic leave requirements created by the Families First Act. There are still some unknowns with the Act, and there are a lot of areas that it would take the full 2 hours we have today to explain thoroughly. But we can give you a foundation for making sure that your company is complying with the requirements of the Act. First, let's go through some vocab. This morning, I'm talking about leave requirements created by the Families First Coronavirus Response Act, which I will be calling the Families First Act for this presentation. The Families First Act includes two acts within it, which actually create the leave requirements: the Emergency Family and Medical Leave Expansion Act, which I will be calling the Emergency FMLA Expansion Act, and the Emergency Paid Sick Leave Act. So who is covered by the leave provisions of the Families First Act? Basically, a lot of companies and organizations. Any private employers with fewer than 500 employees, and all public employers except for some federal employers. Notice that this is much broader than the traditional FMLA, so even employers not subject to the FMLA will be covered by the Emergency FMLA Expansion Act and the Emergency Paid Sick Leave Act. There are a few exclusions and exemptions, and we'll get into some of these later on in the presentation. The Families First Act also creates posting requirements and requires any covered employer to post the DOL's Notice of Families First Act rights, which is posted on the DOL's website. Finally, the Families First Act creates certain tax credits to help employers cover the cost of providing leave under the Act. So that's a brief overview. Now let's start getting into the fundamentals. The Families First Act creates two types of leave: Emergency FMLA leave and Emergency Paid Sick Leave. And while there's a lot of interplay between the two types, they exist as separate entitlements, each with some unique rules. So let's start with the basics of Emergency FMLA leave. Every employee covered by Emergency FMLA is granted 12 weeks of leave, 2 of which are unpaid and 10 of which are paid. However, these 12 weeks draw on the regular 12-week allotment of FMLA hours an employee receives if their employer is covered by the traditional FMLA. So if an employee who is normally allowed 12 weeks of standard FMLA has already used 2 in this 12-month period, that employee only gets 10 weeks of emergency FMLA. And that's if the employee took regular FMLA leave for any reason, not just COVID-19 related reasons. For an employee to be eligible for emergency FMLA leave, they need to have been employed by the employer for the last 30 days. Certain employees who were laid off and later rehired are also eligible. Guidance we've received from the DOL clarifies that being employed for the last 30 days means on the employer's payroll for the past 30 calendar days. So unlike the normal FMLA, there's no requirement that the employee be employed for 12 months or have worked 1,250 hours. It is also important to note that this 2 weeks unpaid, 10 weeks paid only applies to emergency FMLA leave taken for the reasons we'll discuss next. This does not make all FMLA leave paid. And FMLA leave taken for any other reason is still unpaid. So that's emergency FMLA leave. Now let's look at emergency paid sick leave. Full-time employees are entitled to 80 hours of emergency paid sick leave. Part-time employees, which for the Families First Act is anyone working fewer than 40 hours per week, are entitled to the average number of hours they would normally be scheduled to work over 2 weeks. So if you have an employee who normally works 20 hours per week, they would be entitled to 40 hours of emergency paid sick leave. If you have part-time employees with variable hours, the DOL has provided a few different calculations you can use based on a 6-month look-back period to determine how much leave they're entitled to. Unlike emergency FMLA, an employee becomes eligible for emergency paid sick leave as soon as they are hired, and they can start taking it immediately. So that is a very broad overview of what kinds of leave are required by the Families First Act. And now we're going to start getting a bit more into the details. Both the Emergency FMLA Expansion Act and the Emergency Paid Sick Leave Act provide for leave only in very specific circumstances, which are being called the qualifying reasons for leave. The Emergency Paid Sick Leave Act has 6 qualifying reasons, and the Emergency FMLA Expansion Act has only 1. So let's take a look at the 5 qualifying reasons for leave under the Emergency Paid Sick Leave Act. We're going to hold off on that last one because it's also the one reason for leave under the Emergency FMLA Expansion Act. I think it helps to look at every qualifying reason as a 2-step process. First, the employee must be unable to work or telework because of a need for leave based on one of the qualifying reasons. If the employer allows employees to work from home and the employee would be physically able to do that work, the employee is not eligible for leave. They have to be unable to work. The second part is that the employee has to be unable to work because of one of the following things. And we'll go through these reasons one at a time. Reason number 1. The employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. Now, a common question we're getting right now is, do state and local shutdown and stay-at-home orders count as a quarantine or isolation order? And while the answer is technically yes, it's a bit more complicated than that. The DOL's final rule regarding the Emergency Paid Sick Leave Act says that the quarantine or isolation order must make the employee unable to work even though his employer or her employer has work the employee could perform if not for the order. So most stay-at-home and shutdown orders we've seen would not actually qualify an employee under reason number 1. And that's because either the stay-at-home order allows the business to continue operating because it's essential, in which case the employee is not unable to work, or the business is shut down because it is not essential, in which case the employer does not have work the employee could do. So you are likely thinking, when would reason number 1 ever apply? Well, because we're lawyers and we like hypotheticals, we've come up with the following scenario to give an example of when reason number 1 could come into play. Consider an employee who lives in Illinois, works for an essential business in Missouri, and cannot work remotely. Now, let's say the governor of Missouri issues an executive order saying that anyone coming into Missouri from any other state has to self-quarantine for 14 days. So the employee in our example would be unable to work because he would have to go into self-quarantine every time he crossed the Mississippi. But his employer would still have work for him to do because the employer is an essential business and is still open. So there is work, but the employee cannot do it, which means the employee would qualify for emergency paid sick leave under reason number 1. Reason number 2 is much more straightforward. The employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. Simple enough. If an employee's healthcare provider tells the employee to self-quarantine and, it's important not to forget this part, the employee is unable to work, either they can't telework or they're suffering symptoms that make them unable to work, then the employee qualifies for emergency paid sick leave under reason number 2. Now, the healthcare provider's self-quarantine order can be because the employee has tested positive for COVID-19, but it can also be because the employee is particularly vulnerable to COVID-19, which may apply in cases where the employee has an underlying health condition that places them at a higher risk. Reason number 3, also fairly straightforward. The employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. This reason requires the employee to be taking affirmative steps to obtain medical diagnosis, like making and attending an appointment for a COVID-19 test. Reason number 4. The employee is caring for an individual who is subject to a quarantine or isolation order or has been advised by a healthcare provider to self-quarantine. Essentially, an employee qualifies for this reason if they're caring for someone who is subject to reasons number 1 through 3 above, which we've just discussed. But the individual has to be someone the employee would be expected to care for, someone like a family member or a roommate. Now, the last reason is very simple. The employee has a substantially similar condition as specified by the Secretary of Health and Human Services. As of today, the Secretary of Health and Human Services has not specified any similar conditions, so no one qualifies for leave under this reason yet. So those are the 5 emergency paid sick leave only qualifying reasons. The last qualifying reason applies to both the Emergency Paid Sick Leave Act and the Emergency FMLA Expansion Act. We still have the usual first half of the equation. The employee must be unable to work or telework because. And our final reason is the employee is caring for a son or daughter of such employee if the school or place of care of the son or daughter has been closed or the child care provider of the son and daughter is unavailable due to COVID-19 precautions. So let's talk about a few considerations that go into this reason. The employee must be unable to work or telework because they are caring for the child. If the employee can care for their child while teleworking and the employer allows teleworking, then the employee does not qualify for leave under this reason. For example, if the employee can telework and has a teenager who spends 12 hours a day attached to a computer screen with very little need for food or blinking, the employee is not unable to work because they are caring for a child. This kind of leave can also be intermittent, either working from the normal workplace or teleworking. If, for example, an employee only needs 4 hours of leave each day to care for the child, maybe because they have a partner who can care for the child for the rest of the time, the employer and the employee can agree, and they have to agree, to have the leave be intermittent. But because the employer and employee must agree to this, and since the agreement is a really important part, we recommend having a form that can be filled out whenever an employee takes intermittent emergency FMLA leave to document the agreement and to set out, in what increments the employee is going to be allowed to take this intermittent leave. Generally, the child to be cared for under this qualifying reason must be under 18 years old. However, the DOL has clarified that if the employee has an adult child who has a mental or physical disability and who is unable to care for themselves, then the employee could also take leave under this qualifying reason if the child's normal care provider is closed or unavailable for reasons related to COVID-19. No other suitable person can be available to care for the child. If the employee's partner is not working and is able to care for the child, the employee is not qualified for leave. Normally, the child care provider must be compensated, but the DOL regulations waive this requirement if the care provider is a friend or a family member. For instance, if the child's grandparent normally cares for the child while the employee works, but the grandparent is self-quarantining because of concerns about COVID-19, the employee would be eligible for leave to care for the child. Now, I said this reason applies to both emergency paid sick leave and emergency FMLA leave. And that's important because most of the time, an employee who takes emergency FMLA leave can use their 2 weeks of emergency paid sick leave concurrently with those first 2 unpaid weeks. So in that circumstance, they would be getting the whole 12 weeks of emergency FMLA leave paid for. So now we know for what reasons an employee can take leave. But that probably leaves you wondering what is required from the employee in terms of documentation. Any employee applying for any type of leave must provide their name, the dates for which they're requesting leave, which specific qualifying reason they're asking for leave for, and an oral or written statement that the employee is unable to work because of the qualified reason for leave. If the employee gives an oral statement, it's advised to write down and document the statement because you need to keep some documentation. Now, if the employee is taking leave because of a government quarantine or isolation order, the employee also has to provide the name of the government entity. Similarly, if the employee is taking leave based on the advice of a healthcare provider, the employee has to provide the name of the healthcare provider. Now remember reason number 4, taking leave to care for someone else. The same things are required here. If the employee is caring for someone subject to a quarantine order, they need to provide the name of the government entity. If the individual is told to self-quarantine by a healthcare provider, they need to provide the name of the healthcare provider. Now, if the employee is taking leave to care for their child whose school is closed, they must also provide the name of the child, the name of the school, place of care, or child care provider, and a representation that no other suitable person will be caring for the child during the period the employee tends to take emergency leave. Now, whether or not the employer ends up approving leave, the employer must retain the employee's request with the above information for 4 years. To help with record keeping, we would recommend creating a form or having legal counsel create a form that employees can use when applying for leave. The employer must also keep documentation showing how the employer determined how much leave to provide and how much pay to provide. And this kind of documentation might include timekeeping and payroll records. Now we know why an employee can take leave. We know what they need to provide to apply for leave. So let's talk about how much they'll get paid while on leave. There are 2 different pay rates for emergency paid sick leave. If the employee is taking leave to care for the employee, then it's the employee's full regular rate. When paying the employee's full regular rate, payment is capped at $511 per day or $5,110 in the aggregate. If the employee is taking leave to care for another individual or to care for a child whose school is closed, then it's 2/3 of the employee's regular rate. And when paying the 2/3 rate, the cap is $200 per day or $2,000 in the aggregate. For emergency FMLA leave, the first 2 weeks, remember, are unpaid. The remaining 10 weeks are paid at 2/3 the employee's regular rate. Now, a key distinction between emergency paid sick leave and emergency FMLA leave is that paid sick leave is calculated in terms of hours, remember 80 hours of leave for a full-time employee, while emergency FMLA leave is calculated in terms of weeks, 10 weeks at 2/3 the employee's regular rate. This means that when you're calculating how much an employee should be paid during a week of emergency FMLA leave, you need to determine how many hours the employee would normally be scheduled to work in a week. And you would do this using those formulae I mentioned earlier, essentially looking back over the last 6 months. So what if you have an employee who always works overtime? Those overtime hours get calculated into emergency FMLA pay, but you don't need to pay an overtime premium. For example, you have an employee who always works 50 hours per week, 40 straight hours, and 10 overtime. If that employee takes emergency FMLA leave, the employee would get 2/3 of his regular rate for 50 hours during each of the paid weeks. You pay him for those 10 overtime hours he normally works, but only at the 2/3 rate, not at a premium. As with emergency paid sick leave, this 2/3 pay under the emergency FMLA is capped at $200 per day or $10,000 in the aggregate. Now, it's very important to note that when I say regular rate, I'm not necessarily referring to the employee's hourly rate. The regular rate here is the same as under the Fair Labor Standards Act and requires the employer to add in things like commissions and non-discretionary bonuses. Now, it's recommended to consult with counsel when determining the regular rate for your employees, as the calculations can vary significantly based on what compensation must be added into the calculation. Finally, while an employee is taking emergency paid sick leave or emergency FMLA leave, the employer must continue the employee's health coverage and benefits as if the employee were still working. Now, these leave obligations, both emergency paid sick leave and emergency FMLA leave, only apply to private employers if they have fewer than 500 employees. Public employers, you're covered unless you're a federal employer exempted by the OMB. For some companies, it may be easy to figure out whether you have fewer than 500 employees, but for others, it's a much more involved process. So here's a very brief summary about how you go about making that determination. First, who counts? Only employees in the United States count. And both full and part-time employees count. Employees on leave, temporary employees, and day laborers also count. However, independent contractors and any employees who have been furloughed or laid off do not count. Now, for single corporations, you count everyone, including employees in separate divisions and in separate facilities. It gets more complicated when the corporation has an ownership interest in another corporation. In that case, you apply 2 tests. You apply both of 2 tests, the joint employer test under the Fair Labor Standards Act and the integrated employer test under the FMLA. If the answer to either of these tests is yes, I am a joint employer, or yes, I am an integrated employer, then you count the employees of both corporations. Now, both of these tests employ a number of factors and require a very close look at your company's structure and relationships with affiliated companies. So these are determinants that are also best made with the help of counsel. Second, at what point in time are you counting? You're looking at the number of employees on the day leave is taken. If an employee begins taking leave on April 15th, then you count the number of employees you had on April 15th. Now, this may result in a situation where you are covered for some employees and not for others. For example, if on April 5th, my employee Nelson requests to take leave starting that day, and I have 490 employees on April 5th, Nelson gets leave. However, suppose I hire 15 more employees over the next week, and my employee Cathy requests to take leave on April 12th. Well, now I have 505 employees, so Cathy would not be entitled to leave. It is very likely that the Families First leave is not the only kind of leave your company or your organization is offering. You probably also offer some sort of sick time, vacation time, or a general PTO pool. You might also be operating in an area where state or local law requires you to offer some sort of leave, either paid or unpaid. And you might be subject to a collective bargaining agreement that requires you to provide certain forms of leave. Both Congress and the DOL have been very clear about the fact that leave under the Families First Act is in addition to all these other types of leave. This means that the employer cannot deny an employee Families First leave because the employee has used or is eligible for other types of leave. On the other hand, you can't reduce leave offered under your normal policy or as required by another law just because your employees are now eligible for Families First leave. Now, how do these other leaves interact with leave under the Families First Act? First, you have to allow employees to use emergency paid sick leave before they use any other leave. You cannot require or coerce or influence an employee to use vacation time or other leave before using emergency paid sick leave. Second, an employee may choose, or the employee or the employer may require the employee to use other forms of leave to supplement their 2/3 wages under the Emergency FMLA Expansion Act. Essentially, for those 10 weeks that are paid at 2/3 the employee's rate, the employee is allowed to use 1/3 vacation day each day to bring the pay up to full compensation. Now, if both the employer and employee agree, the employee can also supplement their 2/3 pay under the Emergency Paid Sick Leave Act with other accrued time off. Remember that for the Emergency Paid Sick Leave Act, you get that 2/3 pay if the employee is caring for another individual or caring for the employee's child. Now, the important distinction here is that for emergency FMLA leave, either the employee can choose to supplement or the employer can make them supplement, while under the Emergency Paid Sick Leave Act, both the employee and employer need to agree to allow the employee to supplement their 2/3 pay. Now let's talk about some exemptions to the Families First leave. The first is the small business exemption. So who's eligible? Employers with 50 employees can elect the exemption if an authorized officer of the employer determines one of three things. First, granting certain leave would make expenses and financial obligations exceed available business revenues and cause a small business to cease operating. Second, that granting this leave would cause a substantial risk to the financial health or operational capabilities of the business. Or third, there are not sufficient workers who are able, willing, and qualified to perform the employer's work. Now, I said granting certain kinds of leave, and that's really the most important part of the small business exemption. The exemption only applies to leave taken to care for a child whose school is closed or whose child care provider is unavailable. For the emergency FMLA leave, that's the only qualifying reason. So if you qualify for the small business exemption, you don't have to give emergency FMLA leave. However, you'll remember that there are still 5 other reasons an employee would qualify for taking emergency paid sick leave. A small business is not exempt from providing emergency paid sick leave for those other reasons. Also, even if you take the small business exemption, you still need to post the DOL's Notice of Families First rights. Finally, companies don't apply for this exemption. You simply make the determination, and then you have to keep documentation of the determination. And this is important in case one of your employees challenges the determination or the DOL comes back and wants to review the documentation. Recognizing the importance of keeping our healthcare facilities and emergency responder services staffed, Families First Act does allow employers of healthcare providers or emergency responders to exclude certain employees from taking emergency paid sick leave or emergency FMLA leave. Now, this is an affirmative exclusion, which means the employer needs to specifically decide to exclude specific employees. And the DOL has emphasized that this should be on a case-by-case basis, which means the employer should decide exactly which employees are essential to its healthcare objectives and should really only exempt those employees. So who is a healthcare provider or an emergency responder? The regulations do give definitions of both, but there is still some uncertainty, especially in terms of peripheral healthcare providers. Again, this is one of those areas where it's best to have counsel look closely at the facts of your business when deciding which employees you should and should not exclude under this exemption. Finally, it's important to note that this is an all or nothing exclusion. This means that if you exclude an employee from emergency paid sick leave, they are not entitled to emergency paid sick leave for any of the qualifying reasons. The employer cannot choose to exclude the employee only from certain qualifying reasons like caring for another individual, but still allow emergency paid sick leave based on the advice of the employee's own healthcare provider. Of course, an employer could create parallel leave entitlements outside of the Families First Act, but the employer would then not be entitled to any of the Families First tax credits for that leave, which takes us to my final slide. The Families First Act provides for tax credits equal to 100% of qualifying emergency paid sick leave and emergency FMLA leave paid under the Families First Act. Not only do these credits cover the cost of the required paid leave, they also cover the cost of providing health benefits to those employees in an amount allocable to the paid leave wages. Which takes us to my final point. To get the Families First tax credits, the paid leave you are seeking the credits for must be qualifying emergency paid sick leave or qualifying emergency FMLA leave. And what does qualifying mean here? That they are required to be paid out under the Families First Act. If the leave is not required to be paid, then it is not eligible for tax credits. While employers may want to offer leave benefits in addition to what is required by the Families First Act, they should be aware that those additional benefits will not be eligible for tax credits. This means that an employer cannot receive tax credits for leave granted for any other reason not required by the Act, so not one of the 5 or 6 qualifying reasons. Leave granted before the effective date of April 1st. Leave granted if the employer does not have available work. For example, offering paid leave instead of furloughing certain employees. Leave beyond the amount required by the Families First Act. So, for example, offering more than 80 hours of emergency paid sick leave. And leave wages beyond the amount required by the Families First Act. For example, paying an employee's full regular rate for emergency FMLA leave instead of the 2/3 rate. In that scenario, the employer could still receive a tax credit equal to the 2/3 regular rate and would cover the remaining 1/3 on its own. And that was a very brief and practical overview of the new leave obligations created by the Families First Coronavirus Response Act. So with that, I will turn it back over to Nelson. Thank you.
Thanks, Colin. Before we continue, I wanted to let everyone know that we do see and acknowledge the several questions that many of you have submitted via the Q&A widget at the bottom of your screen. We will endeavor to answer those questions at some point during this presentation, but as I mentioned, if we run out of time, we will certainly follow up with each of you by email to make sure that your questions have been fully answered. Now we're going to hear from our law partner, John Viola. John is a partner in our Los Angeles office, and he's going to talk to us about the CARES Act, teleworking, and reductions in workforce. John?
Thanks, Nelson, and thanks, Colin, and good morning to everyone here from Southern California as we enter today our second month of staying at home and staying in place. So let's talk about the CARES Act, which is the Coronavirus Aid, Relief, and Economic Security Act. I mean, there appears to be some confusion out there between exactly what the Families First Act and the CARES Act provides. So what the CARES Act does is the CARES Act is intended to provide emergency assistance and healthcare response for individuals, families, and businesses affected by the COVID-19 pandemic. The CARES Act supplements and in some cases actually amends the Families First Act. So what does the CARES Act provide? This is over an 800-page act. I think it's actually 832 pages. So we're just going to try to hit some of the highlights of the CARES Act this morning. So you probably have heard already about the Paycheck Protection Program provided by CARES. The Paycheck Protection Program is for businesses of no more than 500 employees. The PPP, as it's called, provides federally insured, partially forgivable loans for a 2-year term at a 1% interest rate. But no interest and no principal payments are due for the first 6 months of the loan. The loans are for the period February 15th through June 30th, 2020. The loans can be used to cover short-term operating expenses for up to 8 weeks. And the whole purpose of these Paycheck Protection Program loans is to keep workers employed, to keep everyone at work. You can use the loans for payroll support, such as salaries, sick or medical leave, but you can also use these loans for other operating expenses, such as insurance premiums, mortgage, rent, and utility payments. And importantly, these loans also are available to sole proprietors and independent contractors. And I should also mention something that just came up earlier this week. Some cities, for instance, the city of Los Angeles, are also instituting their own loan program, although I know the Los Angeles program was sold out within hours after it was announced on Monday. So if you're a small business, you may borrow up to 2.5 times your average payroll cost for the preceding years with a cap of $10 million. There are some restrictions on the loans, however. First, there's an annualized cap for loan forgiveness, which we'll discuss on the next slide, of $100,000 annual for each employee. Second, you need to use at least 75% of the loan proceeds to cover payroll costs. So you cannot use more than 25% of the loan for non-payroll costs, such as mortgage, rent, or utilities. In order to qualify for forgiveness of the loans, which after all is a primary feature for most businesses, a business needs to, 1, maintain its number of full-time equivalent employees, and 2, not reduce their compensation by more than 25% during the 8-week period of the loan. Otherwise, if you cut employees or compensation by more than 25%, the amount of forgiveness of the loan is going to be reduced proportionately. And this is an important feature as well because loan forgiveness is excluded from gross income for tax purposes. But if an employer takes a PPP loan, the employer cannot claim an employee retention tax credit. CARES Act also amends and supplements the Families First Act. Now, Colin's already talked about the limitations placed on paid leave and paid sick leave in his presentation, so I'm just going to skip over this slide at this point in the interest of time. Something else you've probably heard about is that CARES also provides for expanded unemployment insurance. CARES creates what's called a temporary pandemic unemployment assistance program, which runs through the end of 2020, and it provides payments to those who are not traditionally eligible for unemployment benefits. So under the pandemic unemployment assistance, people who are typically not covered by unemployment insurance, such as the self-employed, sole proprietors, independent contractors, and also those with limited work histories now are eligible under this unemployment insurance provided by the CARES Act. And it provides unemployment insurance for those who are unable to work as a direct result of the public health emergency. In order for an employee to obtain these extra benefits, however, the state in which the employee works must enter into an agreement with the Secretary of Labor to extend unemployment compensation to covered individuals. So, provided the states enter into an agreement with the Secretary of Labor, an important feature of CARES is that it also increases the amount of unemployment benefits by an additional $600 per week for the period March 24th through July 31st, 2020. Also, importantly, CARES provides that the usual 1-week waiting period can be waived, and I know that California has already done so by executive order of the governor. And finally, another important feature is that CARES provides an additional 13 weeks of unemployment benefits through the end of December 2020 to help individuals remain unemployed after state employment benefits are no longer available. CARES also provides employers with tax relief. I mean, these are pretty complex tax issues, so you'll want to consult your own tax advisor for advice on the tax relief afforded by the CARES Act. Let me just summarize some of that tax relief that's available with that caveat in mind. First, the Employee Retention Tax Credit is a refundable tax credit that reduces an employer's payroll taxes and can be claimed for wages paid after March 12th and before January 1st, 2021. Eligible employers for the tax credit are those who are required to fully or partially suspend operations due to a COVID-19 related order or have gross receipts 50% less than the gross receipts in the same quarter in the prior calendar year. Again, we urge you to consult your tax advisor if you believe you're eligible for an Employee Retention Tax Credit. So that's enough about the CARES Act for now. Let's move to teleworking, which probably most of us listening to this webinar are doing right now. So we've received plenty of questions over the last several weeks about whether or not employers can require their employees to telework. The answer is yes. You may require employees to telework. The U.S. Department of Labor has confirmed that you can do so as an infection control or prevention strategy. This includes situations in which employers impose such arrangements based on current information from the CDC or from state or local public health authorities. And of course, teleworking also may be used as a reasonable accommodation under the Americans with Disability Act. But you need to be careful to make sure that you don't make decisions on who is required to or who is not allowed to telework based on protected characteristics. I mean, we've already handled cases on this very issue long before this crisis arose. And of course, if you're going to require employees or allow them to telework, you need to make sure they have the proper equipment and that it is protected from a cybersecurity point of view. Please make sure that all devices that employees are working on from home are installed with the appropriate corporate security, just like they were working in the office on a normal basis. You also need to make sure to comply with wage and hour requirements for non-exempt employees, including overtime, no working off the clock, and if you're in a state which requires them, meal and rest breaks, such as in California and meal breaks in Illinois. So I ask you to please make sure you have a procedure for employees to record their time and to clock in and to clock out while they're teleworking, because the wage and hour requirements don't go away just because someone is working from home or another remote location. Now, you also might be required to supply the equipment needed for those who don't have the proper equipment to telework. For those employees who do have their own equipment, under California law, you may have to reimburse them for any additional phone, internet, or other expenses incurred to enable the employee to work at your request. And under a Ninth Circuit decision issued only 3 weeks ago today, an employer may be required to pay employees a reasonable proportion of their cell phone or internet bills, even if the employee already had those services and was planning to pay for those services for their own personal use. Now, this doctrine is not just limited to California. Illinois also requires reimbursement of employee expenses that are incurred within the scope of employment. While unlike the case in California, there were no published cases on point, I think we can all anticipate that Illinois may follow California's lead on this issue and require a proportion to be paid of the cell phone and internet bills of employees who are working from home. And let's not forget about the human factor in all of this. I think that a lot of employees are feeling isolated and stressed, not just by the new teleworking environment and the stay-in-place orders, but of course, they have stress because they're fear of contracting the virus itself. So I think we should all try to keep a continuous communication with our employees, such as by phone or video memos, video meetings, memos, emails from management, team leaders, and the like, just to keep morale up. I would try to schedule regular meetings to discuss not just work issues, but how employees are coping with this situation in general. Like, how do they obtain groceries and household supplies, such as paper towels? What are they doing in their free time now that we're all confined to our homes, and things like that. Anything to encourage engagement with each other and with your company, so that when life does return to normal or to a new normal, everyone will be ready, willing, and able to get back to work and to try to interact with each other just as they did before this all started. So last but not least, on the subject of teleworking, if you don't already have a telework policy, now sure would be a good time to get one and to implement it. Just make sure if teleworking is allowed or required for some but not all employees, that you apply the policy in a non-discriminatory manner. I think we can expect more employees to want to telework when we're all allowed back in our offices. I know for one that I prefer my 5-second walk down the hall over my battles every day with traffic on the San Diego freeway trying to get to my office in Century City. So you may wish to reconsider your space requirements if less people will be present physically on a daily basis when we all get back to work. And you also may wish to make adjustments in your network capability, if you haven't done so already, to handle increased network traffic. Finally, let's turn to layoffs and furloughs. And the first thing I want to talk about on this issue is the WARN Act, the Worker Adjustment and Retraining Notification Act of 1988, and the various state mini-WARN Acts. So if you're laying off or furloughing employees, you might have to be concerned with the WARN Act. Now, there's been a lot of talk out there on news articles and by consultants that say that the WARN Acts have been suspended. That is not the case. The federal and state WARN Acts still apply to layoffs, furloughs, plant closings, and relocations despite this crisis. So let's start with the federal WARN Act. The federal WARN Act applies to businesses with 100 or more employees. The WARN Act applies to mass layoffs, which are defined as 500 or more employees at a single site, or constituting 33% of the workforce, or 500 or more full-time employees. The federal WARN Act also applies to plant closings if a shutdown would result in a loss of employment for 50 or more employees in a 30-day period. What does the WARN Act require? Well, if you're engaged in layoffs, furloughs, or shutdowns, which qualify under WARN, you need to give 60 days advance written notice to employees, to various government agencies, and if you're unionized, to unions. But there are exceptions to the notice period, but not to the notice requirement. The exception that's most likely applicable in the coronavirus context of layoffs, furloughs, and shutdowns is the unforeseeable business circumstances exception. This exception includes a government-ordered closing that occurs without prior notice, such as the various state and local stay-in-place orders closing all but essential businesses. But importantly, you still need to give notice if the exception applies. You just don't need to give 60 days notice. You only need to give as much notice as is practicable. which can be very short notice in these circumstances. Moreover, under federal law, a short furlough, such as for a month or two, should not result in a covered employment loss requiring notice. Just make sure that you document when you intend to bring employees back to work, when you're going to reassess whether that date is realistic, and of course, the business reasons for the furlough. And the Ninth Circuit, at least, has held that the WARN Act is not triggered when employment loss is a direct function of a government-ordered shutdown or a direct government action. Now, as I mentioned briefly before, several states, I think there's 10 of them, have their own mini-WARN Act. And California, of course, likes to go its own way. It has its own, what we call the Cal-WARN Act. Unlike federal law, Cal-WARN has no unforeseen circumstances exception and applies even to temporary layoffs or furloughs, including in this crisis. You may have heard that on March 18th, Governor Newsom issued an executive order which suspended application of Cal-WARN. It didn't. All this executive order did was suspend the 60-day notice requirement that must be given to employees. So if you're laying off California employees, even due to the coronavirus pandemic, and you qualify for the Cal-WARN requirements, you still need to give notice to the employees, just not on 60 days. And you still need to give notice to the Employment Development Department and other government agencies. The governor's executive order also states that you must indicate the reason for reducing the notice period on the notice, and that you must provide the wording at the bottom of the slide in the notice to the employees. Illinois also has its own mini-WARN Act, which, unlike California's Act, however, does have an unforeseeable circumstances exception. The Illinois exception, however, only applies to plant closings, not to mass layoffs. And you still need to provide as much notice as it's practicable and explain the reason for the reduced time period on the notice. Finally, on the WARN Act front, let's just turn to the state that's perhaps been most affected by the virus, which is New York. New York also has not suspended its WARN Act. And New York requires a 90-day notice period. And you heard that right. New York has a 90-day notice requirement. That is not a typo on the slide. But the notice may be reduced by unforeseeable circumstances, such as a government-ordered closing. If you're closing a New York facility, you need to immediately notify the New York Department of Labor of why you can't provide this 90-day notice. So we've been talking a lot about layoffs and furloughs, and what's the difference between the two? And what do you have to do in each circumstance? Well, basically, a furlough is just a temporary reduction in hours or an unpaid leave of absence, which eliminates working hours altogether. You can eliminate or reduce the working hours of non-exempt employees by a furlough. And you don't have to pay non-exempt employees for time not worked, of course. If you want to reduce the time worked, instead of eliminating all work completely, you're going to need to make sure that non-exempt employees track all time work, are paid for overtime, and are provided with legally required meal and rest periods where mandated by state law. It's a little bit trickier when dealing with exempt employees who are placed on a furlough. Because if an exempt employee performs any work during a work week, even if it's only briefly reading or responding to emails or making or taking phone calls, the employee must be paid for the full week at their regular weekly salary. If you fail to pay an exempt employee's full week of salary and they do work, you might risk forfeiting their exempt status. So it might be better just to furlough exempt employees for an entire work week, telling them not to do any work whatsoever, rather than placing them on a reduced hour basis. And if you do reduce an exempt employee's salaries, make sure you don't go below the applicable federal, state or local minimum salary requirements for exempt employees. And we've listed the differences on this slide. Again, New York leads the pack at $58,500 a year. So, as you know, and it may be your case also, many employers have been forced, unfortunately, to lay off employees. If you lay off employees because you don't have enough work for them to do, you are terminating their employment and must comply with any wage and hour laws that apply to the termination. In California, you're going to need to make sure that all wages, including accrued but unused vacation time, are paid on the last day of employment. You also need to make sure you give all employees who are laid off notice of their COBRA rights. You might even need to do so if you eliminate hours or reduce hours such that the employee no longer qualifies for group health insurance. And again, it goes without saying, you need to make sure that when you make any reductions in staff, you do it in a non-discriminatory manner and you document carefully the reasons for your decisions as to who is and who is not selected for a layoff or a furlough. And with that, I thank you, and I'll turn it back to Nelson.
Thanks, John. Now we will hear from Cathy Conrad. Cathy is a partner in our St. Louis office, and she is going to talk to us about the employee benefits implications of this moment, specifically the Secure Act, the FFCRA, and the CARES Act. Cathy?
Thank you, Nelson. Good morning, everyone. For employee benefits, there are actually three laws that need to be discussed: the Families First Act that Colin discussed, the CARES Act that John discussed, and the Secure Act that has been somewhat overshadowed by all the COVID-19 legislation and guidance. I'm going to start with the Setting Every Community Up for Retirement Enhancement, or Secure Act, signed by the President on December 20th, 2019. The Secure Act implements key retirement plan and IRA legislation reform, some of which had been in process for many years. Many of these changes were effective as of January 1, 2020. The age for required minimum distributions from all qualified plans and IRAs was increased from 70.5 to 72 for individuals who attain age 70.5 after December 31st, 2019. Despite this change, the required actuarial adjustment factor for defined benefit plans remains at age 70.5. The IRS has indicated this was intentional and not a mistake or oversight. And effective for participants dying after December 31st, 2019, the maximum distribution period for designated beneficiaries under IRAs and qualified plans other than defined benefit plans is now 10 years, except for surviving spouses, beneficiaries not more than 10 years younger than the participant, a minor child of the participant until the age of majority, at which time the 10-year rule applies, and disabled and chronically ill individuals. For these individuals, the life expectancy rules still apply. With respect to the determination of majority, it will most likely be age 18 or 21 based on state law, but we are waiting on confirmation from the IRS. The CARES Act, which we'll discuss a little later, permits plans, other than defined benefit plans, to waive required minimum distributions for 2020. For safe harbor 401k plans that use a non-elective contribution, the safe harbor notice rule was eliminated. And a plan can be amended to convert to this type of safe harbor plan by adopting an amendment until 30 days before the end of the plan year. Or, if amended after that 30th day, a non-elective contribution of at least 4% instead of 3% must be made to the plan, and the amendment generally must be adopted by the last day of the next plan year. For 401k plans that use auto-enrollment and auto-increase, the maximum percentage is raised from 10 to 15% after the first year of deemed election. Effective for plan years beginning after 2020, a 401k plan must now allow part-time employees who are age 21 or older and who have worked more than 500 hours for at least 3 consecutive years to make 401k salary deferral contributions to the plan. The plan is not required to make matching contributions with respect to these deferrals or any other employer contributions for part-timers. Even though this change is effective for plan years beginning after 2020, service prior to 2021 is disregarded, so that the first plan year part-timers will be eligible to participate is 2024. Defined contribution plans and governmental 457B plans may be amended to permit an in-service withdrawal of up to $5,000 per qualifying birth or adoption. The distribution must be taken within 1 year of the birth or adoption, and the 10% early withdrawal penalty for distributions prior to age 59.5 will not apply. Defined benefit plans and governmental 457B plans may be amended to allow for in-service distributions commencing at age 59.5. The current maximum age for DB plans is 62, and for governmental plans is 70.5. The Secure Act also gave access to multiple employer plans. This is not to be confused with multi-employer plans maintained pursuant to collective bargaining agreements. And a covered MEP, as they're referred to, is protected from the one bad apple rule that would otherwise disqualify the entire group of plans if only one plan has a qualification issue. This legislation had been in the works for many, many years. The Secure Act also prohibits the use of credit cards or similar arrangements for plan loans, and it also adopts certain lifetime income provisions, including most significantly for those on the line, requiring defined contribution benefit plan statements to include an estimate of the monthly income of the participant's account balance that would be produced if benefits were received in the form of a qualified joint and survivor annuity or single life annuity. This information is required to be provided at least annually. The DOL is required to issue a model notice and provide the actuarial assumptions to be used in making the computations, and this requirement will be effective for benefit statements furnished more than 12 months after the later of the DOL's issuance of interim final rules or the model disclosure and assumptions. Penalties for plan reporting failures were increased. The penalty for failure to file at $5,500 is now $250 per day, up to a maximum of $50,000, and the penalty for failure to provide a required withholding notice is now $100 per day, up to $50,000 for all failures during a calendar year. Non-discrimination and minimum coverage relief is provided to allow continued accruals in closed or frozen defined benefit plans, and plans can now be adopted after the close of the tax year, provided the plan is adopted by the filing deadline for the employer's tax return for that year. While most of these provisions were effective for plan years beginning after December 31, 2019, plan amendments to comply with these changes are not required until the end of the 2022 plan year. For governmental plans, that deadline is the end of the 2024 plan year. For tax-exempt employers, the unrelated business income tax on qualified parking and transportation fringe benefits enacted in 2017 was repealed retroactively, and certain relief was provided and guidance was provided with respect to church 403B plans. The small employer tax credit for adding auto enrollment to a plan was increased, and contributions to IRAs are now permitted after age 70.5. With respect to health and welfare plans, the big change was the formal repeal of the ACA Cadillac tax, medical device tax, and health insurance provider tax. The Families First Act, signed by the President on March 18th, made more significant changes to group health plans. All group health plans, insured, self-insured, ERISA covered, non-federal government, church, and grandfathered plans are required to cover COVID-19 screening and testing with no cost sharing, that is no deductibles, co-insurance, co-pays, or other cost sharing, and no prior authorization or medical management requirements can be applied. These covered costs must include the cost of the provider visit, no matter the location, whether in office, by telehealth, or in an urgent care or emergency room setting. Further guidance has been issued, and the CARES Act expands these provisions. The only plans not covered are short-term limited duration insurance, retiree-only plans, and ACA-accepted benefits like employee assistance plans and on-site clinics. Frequently asked questions guidance issued jointly by HHS, DOL, and IRS on April 12th provide additional guidance concerning the Families First and CARES Act provisions. Group health plans must comply as of March 18th with the public health until the public health emergency related to COVID-19 is over. The FAQs confirm that plans must cover out-of-network provider costs, but the CARES Act limits the costs that can be charged by both in-network and out-of-network providers. In addition, the FAQs provide timing relief and adopt a non-enforcement policy with respect to the advance notice requirements that would normally apply when a group health plan is modified. The guidance confirms that a plan's summary of benefits and coverage, or SBC, must be amended or a notice provided as soon as reasonably practicable, advising that screening and testing services and telehealth and other remote services are now covered with no cost sharing or prior authorization. The HHS has also issued guidance on HIPAA relief applicable to covered entities, which would include group health plans. Given the layoffs and furloughs being implemented, employers need to be mindful of the ACA employer mandate rules to make sure the plan does not fail to offer coverage to at least 95% of the employer's full-time employees as defined in Code Section 4980H, taking into account the look-back measurement period and stabilization period rules the employer might be using to comply with this rule, and that the cost of coverage remains affordable. Of note, the IRS did not extend the time to file the 2019 forms used to report coverage for purposes of the employer mandate that were due on March 31st. If the employer has a cafeteria plan that allows mid-year election changes, an employee's dependent care account election could be modified due to a change in need for child care, provided the change is consistent with the change in circumstances. For instance, if the need for child care decreased because the child care center closed, the participant can decrease his or her contributions. For group health plans, employees on FMLA leave must be allowed to drop or continue coverage during the leave. The plan can be amended to provide coverage during other leave, provided it does not discriminate in favor of highly compensated employees or against employees based on health status. If there is an insurer or for self-insured plans, a stop-loss carrier involved, you must coordinate with the insurance carrier to make sure the change is communicated to and approved by that carrier. If coverage is continued and the employee fails to make required premium payments, the employee would not be eligible for COBRA. COBRA would be available for employees who lose health coverage due to termination, reduction in hours, or increased contributions or share in premium payment. An employer can subsidize the cost of COBRA coverage provided it is done on a non-discriminatory basis. With respect to other benefit plans like life insurance, AD&D, and disability, the employer needs to review plan documents and insurance policies to determine if benefits continue during any time when employee is not actively working or is working reduced hours. Again, if a change is made to keep coverage in place, the change must be coordinated with the insurance carrier. Once the President made the National Emergency Declaration on March 13th, Code Section 139 allows employers who are financially able to make employment tax-free disaster relief payments to employees to cover the cost of reasonable and necessary personal, family, living, or burial expenses incurred as a result of the emergency to the extent not compensated for by insurance. Not permitted under this code section are income replacement payments. Also, as and when a major disaster is declared in a particular state or region, a major disaster employer-sponsored leave sharing program can be implemented in accordance with the guidelines in IRS Notice 2006-59. This program would allow employees to donate PTO to a bank to be used by those who need PTO and otherwise do not have any of their own. Missouri is one of the states that has requested and received major disaster relief status. The Families First Act did not contain provisions directly related to retirement plans. However, employers looking to save expenses and preserve jobs may look to reduce or suspend contributions. Before doing so, the employer needs to review the type of employer contribution and whether the right to such contribution has already accrued, or whether there are any conditions to reducing or suspending the contributions. For example, discretionary contributions offer substantial flexibility, while safe harbor contributions, either non-matching or matching, would be subject to a number of restrictions. Safe harbor contributions can be suspended in two instances. If the safe harbor notice issued before the beginning of the year reserved the right to reduce or suspend the matching contribution, or the employer is operating at an economic loss. In either case, the employer must provide a supplemental notice at least 30 days prior to the effective date of the change. The plan must be amended, and regular ADP, ACP non-discrimination testing must be performed for the year of the suspension. If the change results in a partial year contribution, a proration of the compensation limit is required. In addition, a significant reduction in force could result in partial plan termination. If a partial termination occurs, employees who terminate during the year must be fully vested. IRS guidance provides that a partial termination is presumed to occur when more than 20% of active participants are terminated in a year. If an employee is on FMLA or other approved leave without sufficient pay, the terms of the plan or loan policy may permit the suspension of loan payments during the period of leave up to 1 year. The suspension period does not extend the term of the loan. IRS Notice 2020-23, issued on April 9th, provides some relief by allowing the deferral of all loan payments for the period April 1st to July 15th, 2020. An employer who has employees taking paid leave, whether through the EPSLA or FMLA that Colin talked about or otherwise, needs to review the terms of its 401k plan to determine if employee deferrals or employer contributions will be based on those payments. The IRS FAQ guidance indicates salary reduction contributions may be withheld from payments received under those emergency leave programs. The IRS in Notice 2020-18 extended the deadline for making tax-deductible contributions for a calendar year employer to July 15th. On March 27th, the IRS announced the extension of the deadline to adopt pre-approved 403B plans from March 31st to June 30th and to adopt a pre-approved defined benefit plan from April 30th to July 31st. On April 9th, the IRS issued Notice 2020-23 modifying and expanding all earlier guidance extending until July 15th the deadlines to complete certain plan actions, including loan payments extended for all participants, excess deferral refunds, excess contribution refunds, excess aggregate contribution refunds, completing a 60-day rollover only if the period ends after March 31st, 2020, Form 5500 filing, EPSLA, self-correction for certain significant failures, and distributions to satisfy the substantially equal periodic exception to the 10% early distribution penalty, and certain required minimum distribution receipts. The CARES Act provides further relief for certain plans. This notice does not provide relief for deadlines that occurred on or after March 13th and before April 1st, or for retirement-related notices, disclosures, reporting, and filing deadlines other than those identified. Moreover, ERISA deadlines were not automatically extended by the notice. For example, quarterly benefit statements, annual funding notices, and claims procedures deadlines. The CARES Act provides the DOL with the authority to extend those applicable deadlines for up to 1 year, but we are still waiting on guidance from the DOL. The CARES Act, signed on March 27th, provides relief through increased access to retirement plan funds and by expanding the preventive services to be covered by group health plans. Retirement plans are permitted, not required, to offer coronavirus-related distributions and loan relief to qualified individuals. Qualified individuals include participants, beneficiaries, and alternate payees who are diagnosed with or have a spouse or dependent diagnosed with COVID-19 by a CDC-approved test, or experience adverse financial consequences as a result of being quarantined, furloughed, or laid off, or having work hours reduced, being unable to work due to lack of child care, closing or reducing hours of a business owned or operated by the individual, or other factors determined by the IRS. Qualified individuals are permitted to self-certify the need for the distribution or loan, and the plan is not required to confirm which criteria applies. Coronavirus-related distributions to qualified individuals are permitted during 2020 only. The maximum distribution amount is $100,000 in the aggregate from all plans of the employer. The 10% penalty for distribution prior to age 59 and a half is waived. The amount is included in income ratably over 3 tax years. The amount can be recontributed within 3 years, and when recontributed, the amount is treated like a rollover. No eligible rollover notice required, and 20% mandatory withholding does not apply. Instead, optional 10% withholding rules apply. Before adding this distribution option, sponsors need to consider the long-term impact such a distribution may have on the retirement income of a participant, given that the size of the distribution may well exceed the need, and once taken from the plan, it is likely the funds will not be returned. Loans to qualified individuals only between March 27th and September 23rd, that is 180 days after enactment, may be made in greater amounts. The maximum loan amount is the lesser of $100,000 increased from $50,000 or 100% increase from 50% of the participant's vested account balance. Loan payments between March 25th and December 31st, 2020 can be delayed for 1 year. Interest continues to accrue, and the delay is not included in determining the 5-year maximum loan term. If implemented, the plan or plan loan policies may also need to be amended to increase the number of plan loans permitted. Many plans limit participants to 1 loan at a time. Also, the sources from which a loan may be taken may need to be modified. Some plans do not allow loans from all or some employer contribution sources. These increased limits raise possible ERISA issues that the DOL has yet to weigh in on, but based on prior disaster relief situations, it is believed the DOL will provide non-enforcement relief. In addition, IRAs, including inherited IRAs and defined contribution plans like 401k plans and profit-sharing plans, 403A, 403B, and governmental 457B plans, but not defined benefit plans, are permitted to waive required minimum distributions for 2020. This applies to 2020 RMDs and the first-year RMD for a participant who turned 70 and a half in 2019 and delayed his or her first payment until April 1st, 2020. In certain circumstances, an individual who already took an RMD may be able to recontribute the amount to the plan or IRA. If a distribution that would otherwise have been an RMD is made in 2020, the distribution is an eligible rollover distribution, but the eligible rollover distributions will not apply. There is no 204F notice and no mandatory 20% withholding, just like the waiver in 2019 under WERA for those who have been practicing in this area long enough to remember WERA. Single employer defined benefit plans are provided funding relief by delaying minimum funding payments due in 2020 until January 1, 2021, and permitting use of the 2019 funded percentage for 2020 benefit restrictions. Further funding relief for defined benefit plans is actively being sought in Congress. Sponsors have until the end of the 2022 plan year to amend the plan to reflect plan operation. And again, for governmental plans, the deadline is the end of the 2024 plan year. During the public health emergency related to COVID-19, the CARES Act is further clarified by the TRA agency FAQs issued on April 12th, and it requires group health plans to cover, with no cost sharing and no prior authorization or medical management requirements, the following additional tests and services: in vitro diagnostic tests, including serological tests for COVID-19 used to detect antibodies against the virus and used in the diagnosis of the disease or condition, and the administration of such tests. Provided the test is approved, cleared, and authorized by the FDA, the developer has requested or intends to request emergency use by the FDA, is developed in and authorized by a state that has notified the Secretary of the HHS of its intention to review tests intended to diagnose COVID-19 or other tests the Secretary of HHS determines is appropriate. In addition, items and services furnished to an individual during a healthcare provider office visit, including in-person and telehealth, urgent care visits, and emergency room visits that result in an order for or administration of an in vitro diagnostic test product, but only to the extent the items and services relate to the furnishing or administration of the product or to the evaluation of the individual for purposes of determining the need for such product, must be covered. The plan or insurer must cover the cost of in-network and out-of-network providers at a negotiated rate with the provider, and if there is no negotiated rate, at an amount equal to the cash price for the services as listed by the provider on a public internet website, or a negotiated rate at less than the cash price. HHS has authority to impose civil penalties up to $300 per day on any provider that does not comply. As mentioned earlier, mid-year plan changes to adopt these rules are permitted with delays in the timing for the issuance of the required notices and non-enforcement policy during the crisis period. And effective for plan years beginning on or before December 31, 2021, high-deductible health plans are permitted to cover telehealth and other remote care services below the deductible without endangering the plan's HSA eligibility. A couple of items to note: the ACA restrictions on reimbursement for over-the-counter medical products without a prescription from a health savings account, health flexible spending account, or Archer medical spending account was repealed. And for the period March 27th to December 31st, 2020, qualifying educational expenses under an educational assistance program may include student loan payments. The maximum dollar amount for 2020 for all eligible expenses under the program remains at $5,250. And with that, I turn it back over to Nelson. Thank you.
Thanks, Cathy. Now we will hear from Oslica. Amy is an attorney in our St. Louis office who is going to give an overview of state-specific considerations in light of COVID-19. Like Colin, Amy has devoted significant time to analyzing the various requirements implemented by states across the country. Amy?
Thanks, Nelson. Thank you to Colin, John, and Cathy, and everyone else for joining us this morning. Like Nelson said, for the past few weeks, our group has been focused on these new federal laws, but also more specifically on these state issues related to COVID-19. And I'm guessing that many of you have just as many questions about these state requirements. My purpose here is to give you a brief overview of some state-specific issues that we're seeing come up. I'm going to talk very briefly about social distancing and then how that plays into the stay-at-home and shelter-in-place orders that we're seeing many of the states issue. I'm also going to discuss the expansion of unemployment insurance benefits and then state-specific paid leave, sick leave laws that are in addition to the Emergency Paid Sick Leave Act that Colin talked about earlier. I'm sure that you are all probably very well aware of social distancing requirements, especially if you are listening to this webinar from the comfort of your own couch this morning. If you review many of the stay-at-home or shelter-in-place orders that states and counties and even cities are issuing, you'll notice that they are requiring employers to adhere to social distancing to the maximum extent possible. To practice this, the CDC recommends staying at least 6 feet away from other people, not gathering in groups, staying out of crowded places, and avoiding mass gatherings. As I mentioned, most of these stay-at-home orders will have the caveat that employers should adhere to social distancing to the maximum extent possible. For example, we have clients that operate production lines, and for those employers, it may be difficult for their employees to keep a 6 feet distance away from each other. However, you need to consider these social distancing requirements outside of that specific context. For example, in lunchrooms, when people are lining up to punch their time cards, how can you, as an employer, help your employees keep these social distancing guidelines in place? Nearly every state now and many counties and municipalities have issued stay-at-home or shelter-in-place orders. There's only 5 states right now that don't have an order in place. Those are North Dakota, South Dakota, Nebraska, Iowa, and Arkansas. The details of these stay-at-home orders vary, but most require that employers either force employees to work from home, if that's possible, or if they can't, to temporarily cease their operations for the period of that stay-at-home order. Of course, there are exceptions to these orders if a company is essential to infrastructure, governmental activities, or public health and wellness. So we're seeing 2 categories of these stay-at-home orders kind of emerge. One is states that include guidance from the Department of Homeland Security. We're referring to this as the CISA guidelines because it is the Cybersecurity and Infrastructure Security Agency that issues these guidelines. So almost all of the states are incorporating that guidance into their stay-at-home orders. There's another category of states that do not and have listed their own categories of essential businesses. That group of states is a lot smaller. For example, Illinois is one of those states. Pennsylvania is one of those states, although at this point, their guidance indicates that they're referring to the CISA guidance when they're determining if a business should be deemed essential. A lot of these I have listed on the slide here. A lot of these essential businesses, you won't be surprised as to what they are. Grocery stores, big box stores, pharmacies, garbage collection, healthcare operations. These are the things that you're hearing a lot about on the news that need to stay open. We all need groceries. We all need our trash to be picked up. But there are a number of other essential businesses as well that you maybe would be surprised would be included. And as I said, those vary very much by state, but the CISA guidance is very helpful in determining. So who's deciding if a business is essential? each individual issuer of the stay-at-home order is in charge of determining compliance and exceptions within its jurisdiction. And all the states are listing categories of businesses that will be exempt. Like I said, either they're listing them themselves or they're incorporating the FFCRA guidance. In most of the states, the business itself needs to make the decision as to whether it's essential and then be prepared later to defend its decision if it's challenged. Other states, and there's only a few of these, are requiring businesses to apply for essential business status and obtain a certificate in order to continue operations. What we're seeing is local authorities asking businesses for an analysis as to how the business is essential. We've only seen a few instances of this, but it is something that employers should be aware of. This is obviously a very dynamic situation. We're seeing states issuing amended orders. That seems to be slowing down a little bit now, but in the past few weeks, states are amending their orders, updating their definitions of essential employers. So things are really continuing to evolve, and state agencies are issuing more guidance. So it's very important to frequently check for new orders or amendments. See if your state is issuing more guidance on what their executive orders mean, what qualifies as an essential business. There are a few other issues that are coming up, and I have a feeling that many of you have questions about this too. One thing is whether employees or businesses need permission slips in case they're stopped by law enforcement. We've seen that every now and then an employee will be stopped by a local police officer and ask them what they're doing out and about. We recommend that if you have decided that you are an essential business and you've made that legal determination and you're in a jurisdiction that has a stay-at-home order, you can put together pretty simply an essential worker letter that your employee can provide to law enforcement that explains how you've analyzed and determined that you're an essential business and that this employee is coming to work for you and is an essential employer. One other issue is whether someone calls to complain that your business is still open and says, I don't think this business is essential. I think your response to this is definitely going to depend on the jurisdiction, but the biggest thing here is to be proactive about your analysis and make sure that you have reviewed all of the orders. Maybe you've gotten a legal opinion about the fact that your business is essential and can remain open at this time. When you're doing that, you might notice that your industry isn't explicitly mentioned by the stay-at-home order in your state. That does not mean that your business is not essential. These orders, as we've seen in the past few weeks, can be kind of clunky, a little bit difficult to follow, and so your business may fit into a category by virtue of being part of a critical supply chain, for example. So if you're having trouble figuring out if there's a way for your business to fit in as an essential business, work with legal counsel to do that analysis. I'm also going to talk a little bit about how unemployment insurance benefits have been extended in multiple states. As John mentioned before, the CARES Act expands unemployment benefits specifically for eligibility requirements. Individuals who may not have been eligible for unemployment benefits before under the CARES Act now may be. But in addition to the CARES Act, individual states are implementing changes to their unemployment insurance programs. These are incredibly state-specific, but there are a number of trends that we're seeing emerging. The two major trends that we're seeing are waiving the waiting period before an individual is eligible to receive unemployment benefits. As John talked about, this is something that's permitted by CARES. Most most states have a 1-week waiting period before an individual can receive benefits, but we are seeing a high number of states that are waiving that 1-week period requirement. The other major trend we're seeing is states are waiving the work search requirement. So in most states, to be eligible for unemployment benefits, an individual has to be actively seeking out employment. And states are obviously, given social distancing, actively seeking out employment may not be something that's possible. And so in many states, they're waiving this work search requirement. There are a few other trends that employers should be aware about too. Many states are waiving employer charges for COVID-related claims. So there are 3 kind of approaches that states are taking. The first is that employers will not be responsible for any benefits awarded during and paid during COVID-19. A lot of the states, this is the biggest option that we're seeing being implemented. And they're saying, these states are saying if any benefits are awarded during this time, employers are not going to be responsible and they're going to be paid out of the fund. Alabama, on the other hand, requires the employer to file on the employee's behalf for the waiver to apply. Michigan is only doing this for employers that are required to close under an executive order. Those employers will not be charged for unemployment benefits. A few other trends. One is not assessing employers certain experience rate penalties for unemployment claims related to COVID. Requiring employers to provide employees with information about unemployment benefits in Alaska. That has to be done within 7 days of the employee's last day of work. And also requiring employers to file partial unemployment claims on behalf of employees if there's reduced work or no work due to COVID-19. That's happening in Georgia. I think it's important to take note of the employment insurance changes in your jurisdiction to see what benefits are available to you as an employer, and then if there are any new responsibilities that you might have, like in Alaska, providing the employees with information that might not have been something that you were doing before, but now it's required. So keeping apprised of those requirements to make sure that you're in compliance as things continue to evolve. The last thing that I wanted to talk about is paid sick leave. Colin discussed emergency paid sick leave under the Families First Act, but actually many states had previously enacted paid sick leave legislation, and it surprisingly addresses situations that we're seeing that are seemingly unique to coronavirus. A while ago, when I was researching paid sick leave, I remember reading some of these provisions and thinking, that's wild. I don't know that that would ever happen. And now here we are. Other states and localities have also passed paid sick leave laws in response to the pandemic. So we'll cover a few of these. So generally, these paid sick leave laws require that employees of certain employers accrue paid sick leave based upon the number of hours worked. So just as an example, in Arizona, employees accrue 1 hour of paid sick leave for every 30 hours that they've worked. That is a very basic overview, and these paid sick leave laws have quite a bit more detail, but that's the gist of it. Generally, the legislation lists the permissible uses of paid sick leave. So I would say as a general rule, the permissible uses of paid sick leave are similar to FMLA. It's for an employee's mental or physical illness, diagnosis, care, or treatment, caring for a family member. However, there are a few states and localities that have included other provisions. The 2 big ones are closure of an employee's place of business by order of a public health official for a public health emergency. Very relevant to us now. Also, closure of an employee's child's school or place of care due to an order of a public health official. The states that have those specific permissible uses in their paid sick leave laws are Arizona, Michigan, New Jersey, Oregon, Vermont, and Washington. In addition to the states that already had passed paid sick leave legislation, we're also seeing paid sick leave legislation being passed in response to COVID-19. I think Colorado was the first state to implement a new paid sick leave law specifically for COVID-19. Colorado's law provides up to 4 days of paid sick leave for permissible reasons. Those permissible reasons are pretty narrow. It's if an employee has flu-like symptoms and is being tested for COVID-19. Now, the 4 days of paid sick leave automatically ends if the test is negative. New Jersey's paid sick leave law that they passed to account for COVID-19 is a little bit broader. It has new permissible uses for paid sick leave under New Jersey's paid sick leave law. The first is a determination that the employee's presence in the community or family member needing the employee's care jeopardizes others' health. The second is if the employee is under isolation or quarantine or caring for a family member in quarantine due to suspected exposure to a communicable disease and a finding that the presence in the community of the employee or family member jeopardizes others' health. Finally, New York also implemented a new paid sick leave law specifically for COVID-19. Employees are eligible for paid sick leave if they're subject to a mandatory or precautionary quarantine order, but not if an employee is asymptomatic or has not been diagnosed, or if the employee is physically able to work remotely. In New York and in many of these other states with paid sick leave laws, the number of days that an employee is entitled to is going to be dependent upon the size of the employer. So in New York, for example, if the employer has 10 or fewer employees, the employee will have job protection, but will not have a paid sick leave entitlement. So the employee may have leave, but not paid sick leave. If the employer is between 11 and 99 employees, the employee also has job protection and at least 5 days of paid sick leave. And any employer who has 100 plus employees, those employees are going to be entitled to job protection and at least 14 days of paid sick leave. With that, I will turn it back over to Nelson to talk about some scenarios.
Thanks, Amy. And so as Amy mentioned, I'm going to go over a few of the common scenarios that businesses might encounter in their day-to-day operations. So over the last few weeks, as you've seen during the course of this webinar, Congress has passed several laws, brand new laws that have really implemented new requirements for businesses as we navigate this moment. And so we have a lot of new guidance here to sort of pour through in order to figure out what applies into what situations. In fact, the Department of Labor has released regulations and guidance in the form of about 79 frequently asked questions to cover some of the many ways in which these new laws might impact our daily lives. So let's go through a couple of them together. So here's our first scenario. We've got an employee named Susan. She's a full-time, non-essential employee of a company that is subject to the Emergency Paid Sick Leave Act. The mayor of her city enters a 2-week quarantine order that requires Susan to remain at home. Now, due to the nature of her job, Susan cannot work remotely. Her company provides her with 2 weeks of full-time pay under the sick pay law. Now, a month later, Susan begins experiencing COVID-19 symptoms, or symptoms that she believes could be related to COVID-19. So the question is she entitled to additional sick leave under the EPSLA? And the answer to that question is generally no. So eligible employees are entitled to up to 2 weeks of paid leave for any combination of qualifying reasons. However, the total number of hours is capped at 80 hours. So there's not a separate bank of 80 hours of leave for each qualifying reason, or for each qualifying potentially COVID-19 related reason. So here, the answer would be no. Our next scenario. So on April 21st, we have an employee named Connor who requests time off to care for his wife, who was advised to self-quarantine due to COVID-19 concerns. He wants to begin taking this leave on April 25th. On April 24th, the company closes the work site in which Connor works. Is Connor still eligible for leave on April 25th? And the answer is no. Connor is not eligible for sick leave. And where to return to this, there's actually an FAQ on this. It's frequently asked question 24 on the DOL guidance. And the law states that if an employer closes after the FFCRA became effective, an employee is not eligible for leave even if they requested leave prior to the closure of that facility. This is true whether the employer closes due to lack of business or because it was required to do so due to a federal, state, or local order. Now, although in this scenario Connor is not eligible for leave, he may be eligible for unemployment insurance benefits. Now, turning back to our scenarios, we have same fact pattern except a different employee named Laura. Laura works at the same company. She began taking sick leave on April 18th. So that was a week before this company shut down. Now, is she entitled to sick leave on April 25th? Now, the answer is slightly different here. So with Laura, the employer would be required to pay sick leave for the time she already took beginning on April 18th. However, once the employer closed, she would no longer be entitled to leave. Like Connor, however, she may be eligible for unemployment insurance benefits. And again, we turn to frequently asked question 25 for this particular guidance on these issues. So whether and when employees are eligible for leave depends on whether or not they actually started taking their leave before the employer shut down their operations. Our next scenario. Whitney has requested time off to care for her daughter, Mariah. Mariah has a serious illness and is currently undergoing treatment. Mariah is 35 years old, divorced, and lives alone. Mariah's ex-husband, Tommy, lives 45 minutes away. There is no stay-at-home order in place for the state or city in which they live, but Mariah's doctors advised her to self-quarantine given her medical condition. Whitney claims that her care for her daughter is covered under the sick pay law. Her employer tells Whitney her daughter is not covered. Who is correct? Well, we've got a couple of things going on here. We've got a woman, Mariah, who is over 18, but she has a serious illness. There's no stay-at-home order in place. However, Mariah's doctors have advised her to self-quarantine because they believe she could be at additional risk of getting infected or suffering a serious illness should she contract COVID-19. So is she covered or is she not? Well, likely, yes, she would be covered. But of course, because we're attorneys, there are some qualifications that we have to give along with that answer. So under the FFCRA, son or daughter includes biological, adopted, foster child, a stepchild, a legal ward, or a child for whom you are standing in loco parentis. It also includes individuals who are over the age 18 if they, 1, have a mental or physical disability, and 2, are incapable of self-care because of that disability. Now, the regulations provide that an employee can take paid sick leave to care for someone if the relationship with that person creates an expectation that you would care for that person in quarantine, and that individual depends on you for care during quarantine. So in this situation, Whitney, the parent, would likely have to show that caring for Mariah prevents her from working or teleworking, and that, in fact, her relationship, the fact that she's her mother, creates an expectation that she would be the one caring for Mariah. We see some facts about this in the situation, the fact that Mariah's ex-husband lives 45 minutes away, her mother presumably lives closer, and due to their mother-daughter relationship, although Mariah is over the age of 18, she has a serious illness, has been advised to self-quarantine, and the close relationship between Mariah and Whitney creates the expectation that Mariah would obviously be dependent on Whitney, her mother, for care. So in this situation, likely yes, this request would likely be covered under the sick pay laws. Our next scenario. So in January 2020, Charlie took 2 weeks of FMLA leave to recover from a surgical procedure. In May 2020, Charlie requests expanded family leave under the FFCRA to care for his children whose school has closed due to COVID-19 related reasons. How many weeks of expanded family leave is Charlie entitled to? And the answer is 10 weeks. So remember, as Colin overviewed at the beginning of our webinar, employees may take a total of 12 weeks of FMLA or expanded family and medical leave during a 12-month period. If they have taken some, but not all, of the 12 work weeks during the current 12-month period, they may take the remaining portion of that leave that is available. Remember, everyone, emergency FMLA leave is a type of FMLA leave. It's a subset of it, so therefore we're pulling from the same set of 12 weeks. So here in the situation, Charlie would be eligible for 10 weeks of additional leave. Our next scenario. Kelly began experiencing COVID-19 symptoms on April 28th. Out of an abundance of caution, Kelly decides to self-quarantine so that she does not potentially expose others. Although she remained in self-quarantine for 2 weeks, Kelly did not seek a medical diagnosis or the advice of a healthcare provider. Is Kelly eligible for sick pay for the 2 weeks she remained off work? And the answer is generally no. And here we turn to FAQ 62 under the DOL regulations and guidance. So if you become ill with COVID-19 symptoms, you can take paid sick leave under the FFCRA only to seek a medical diagnosis or if a healthcare provider otherwise advises you to self-quarantine. You cannot take sick paid leave under the FFCRA if you unilaterally decide to self-quarantine for an illness without medical advice, even if you have COVID-19 symptoms. So here in the situation, she would not have been eligible for 2 weeks for pay for those 2 weeks that she took off because she did not seek medical diagnosis. Moving on to our next scenario. Ryan has a daughter whose school has closed due to a state shutdown order. Although the physical location where the school takes place is closed, the school has switched to online classes. All teachers are available and regularly meet online to provide their normal course of instruction for the students, and Ryan's daughter is still expected to complete assignments. Ryan requests expanded family leave under the FFCRA to care for his daughter. Is Ryan eligible for leave? The answer here is generally yes. If the physical location where a child receives instruction or care is now closed, the school is closed for purposes of the FFCRA. This is true even if some or all instruction is being provided online or whether the child is still expected or required to complete assignments. However, as Colin mentioned at the outset of our presentation, Ryan would need to demonstrate that he was unable to work or telework because he was caring for his child and that no other suitable person is available to care for the child as well. So that concludes our scenarios. And again, we wanted just to give you a brief overview of the types of scenarios, common questions that we have received over the last month or so as we begin to traverse this new landscape with the FFCRA and COVID-19 related laws. We have about 11 minutes remaining or so, and as promised at the outset, we're going to spend some time now going through the questions that you all have submitted throughout the pendency of our presentation. Now, we've got about 27 questions that have been submitted, and they're all fantastic, really great questions. Some a little more detailed than others, and as we mentioned at the beginning, we're going to have to spend a little time digging in a little bit, and we will reach out to you directly if your question is a little more nuanced or requires more research or an analysis or is a highly fact-specific question. However, for some of the more general questions, we're going to spend time now going through those a little bit. And so I will turn over to Colin. I think he's going to take our first question for us, and we will go from there.
Thanks, Nelson. So, like Nelson said, we've received a lot of great questions, and we're just going to run through a few of them that we have time for right now. So our first question is, what if my company does not offer FMLA leave? And this is a great question. Even if your company is not required to provide traditional FMLA leave, you must still provide emergency FMLA leave if you're covered by the Act. So if you're a private employer with fewer than 500 employees, or if you're a public employer who normally complies with the FMLA. So even though you don't normally have to provide FMLA leave, you do have to provide emergency FMLA leave. One of the aspects of emergency FMLA leave that this affects is that 12-week pool. There's nothing else drawing from it. So your employees are entitled to the full 12 weeks, 2 weeks unpaid, 10 weeks paid. Okay, for our second question, we've been asked if we have any advice for employers with more than 500 employees who are not subject to the Families First Act, whether it would be advisable to develop a policy to cover the qualifying reasons. First, you need to make sure that there are no local or state laws, as John and Amy have discussed, some of which essentially expand the Families First coverage to employers with more than 500 employees. John, could you tell us a little more about that?
John, I want to make sure that your speaker is still working. Can you hear us?
Now I can hear you. Thanks, Colin. Yeah, there are 3 cities in California, the cities of Los Angeles, San Francisco, and San Jose, who have passed their own local ordinances within the last 2 weeks, which eliminate the so-called big box exception for large employers. And there are also efforts in Congress to eliminate this exception. So it's important to keep up with what's going on in your local jurisdiction, because this exception may become a thing of the past quickly.
Thanks, John. Continuing with this question, you're generally free to implement your own leave policies. But before you do so, you want to be sure that you're aware of your state's laws regarding PTO and vacation policies before you instate the new policy, to know what you're getting into, if you'll have to pay out certain times of leave at termination, and issues like that. A third point for this question is it might be advisable to develop such a policy to make sure that you don't have employees who are coming into work when they could potentially be carrying the virus. For example, when they're exhibiting symptoms of COVID-19. If an employee is exhibiting symptoms and they aren't receiving paid leave, they might be more likely to come into work. And now we're going to turn it over to Amy for another question.
Yes, so someone asked about where you can find any amendments to orders or the orders themselves. Almost all the states on their official website, and most of the counties too, have made a specific page for COVID-19 related issues. And that's where they're posting copies of these orders and amendments. So that would be the first place to look for them, and probably the best place to look for them, because some information on the internet might be outdated. So I would go straight to the source and look on your state's website.
Great, thanks, Amy. Our next question is going to be taken from John in California. John?
Thanks, Colin. We've received a question: how many hours would qualify as a full-time equivalent for the Paycheck Protection Program? And unfortunately, we don't know the answer to that. The Small Business Administration has not yet specified how to calculate FTEs. There's another program under the SBA, which assumes that a full-time equivalent is 30 hours a week. And the SBA has used 130 hours per month also as a full-time equivalent and used 120 hours for part-time. So we really don't know the answer. The IRS uses the 30 hours per week, 130 hours per month as a full-time equivalent as well, but they also have a very detailed calculation on how you arrive at who's a full-time equivalent. So unfortunately, at this point, we don't know the answer, but a good rule of thumb, I think, would be 30 hours per week / 130 hours per month.
Great, thanks, John. Our next question is, does an employer have to pay an employee emergency paid sick leave if they keep the employee home while the employee's spouse is being tested for COVID-19 and the results are not back yet? This is a great question, and it touches on two of the qualifying reasons that we discussed earlier in the presentation. Remember that you only have to provide emergency paid sick leave for a qualifying reason. Now, the scenario suggested by our participant could fall under reason number 4, which is caring for an individual who has been advised by a healthcare provider to self-quarantine or is seeking a diagnosis. And that's assuming that the spouse's healthcare provider told the spouse to self-quarantine before receiving the test results. In that case, the employee could provide their documentation that they need leave to care for an individual, that they won't be able to work while they're doing it, and that they need to provide the healthcare provider's name along with that documentation. This question might also fall under qualifying reason number 2 if the employee's own healthcare provider advises the employee to self-quarantine because they have been in close contact with the spouse. In that case, the employee would be at a greater risk from COVID-19, and the employee's healthcare provider might tell him to self-quarantine.
Thanks, Colin. There's one question that I saw that I thought was an interesting one, and it related to one of the scenarios that we just went over. It's from Ashley. And her question was, what documentation would be acceptable for Ryan to provide to verify he's unable to work / telecommute and has no one else available to watch his child? And when she's talking about Ryan, she's referring to the scenario that I went over. If you recall, Ryan was the individual whose daughter's school closed and was receiving online instruction, but he wanted to take off leave in order to care for his daughter because her school was closed. And so the question is, what documentation does Ryan need to provide in order to verify that he, in fact, has to care for his daughter? So going back to Colin's presentation, there were a couple things that employees must provide. They have to provide their name, the dates for which leave is requested, a qualifying reason, and an oral or written statement that the employee is unable to work because of the qualifying reason for leave. So those are things that he has to provide, and he doesn't necessarily have to provide that in writing. He can provide an oral reason. Obviously, we would want something more in writing because it's going to be a better way of keeping our records verified. I think a best practice would be that if an employee tells you something orally, that we as employment and HR professionals document those reasons to make sure that we know and keep our records in line. The additional information in the case of Ryan would be the name of the child and the name of the school or care provider, and just a representation that no other suitable person will be caring for the child. But again, that can be done orally or in writing. Colin, do you have anything to add to that?
No, I think that was a great answer, Nelson.
Perfect. Well, I think
we have time for one.
Go ahead.
For one final question. This is a quick one. We have a question about the Families First Right posters. So you remember that the Families First Act requires you to post the DOL's model notice, and this participant wants to know if they have to include the materials with onboarding, or if handing the notice out in the workplace is enough. Luckily, the DOL has told us exactly what we may do to satisfy the posting requirement. Employers can either post the notice in a conspicuous place in the workplace, email or direct mail it to employees, or post it on an employee informational website. So any of those ways will satisfy the DOL's posting requirement.
Great. Thanks, Colin. And with that, I again want to thank the 221 of you who attended our webinar today. I also want to remind you that our annual Labor, Employment, and Employee Benefits Seminar, which was originally set for today, will take place on September 1st, 2020. Feel free to reach out to any of today's presenters for additional details, and we hope to see you there. Finally, please complete and submit the survey that will display at the conclusion of this webinar. And again, thank you. Take care.